Hi everyone, welcome to the PEB channel. I'm Joel Pettit, and today I want to talk to you about the Springs v. Del Toro case and the notices that are coming out from the Navy to notify sailors and Marines about their rights under this case. Why am I doing this? Because I've gotten a lot of questions and emails about the notices and the matrix that the Navy is sending along with these notices and how to read them. And all you really have to know is the underlying logic of bundling conditions. Because remember, Springs is not the same as Torres. These are two different cases. Springs is based on Sissel v. Warmouth. That's an Army case. And both cases, meaning Springs and Sissel, will be linked below. But it's based on bundling. Torres was not that. So, what do I mean by bundling? It's this simple. There are Category 1 conditions, which are unfitting conditions. Category 2 conditions, which are conditions that contribute to or exacerbate the Category 1 condition. And when I say categories, I mean when you look on your finding sheet, when you went to the PEB, there are Category 1, Category 2s, and you'll see them. But the Category 2s, it doesn't necessarily, it's not in a separate box or anything. It just says, let's say you were unfit for a back condition, and it's just one condition. Then that'll be 1, Category 1, and it'll say number 1. Let's say you had bilateral radiculopathy for your right and left lower extremities. It'll have 1.1, which would be, let's say, your left lower extremity, then 1.2, which would be your right lower extremity. That's simple. Well, under Sissel, the PEB should have taken those individual conditions and the associated VA disability ratings and added them up. They didn't do that. They just took the Category 1 condition and that rating and said, well, that's what it is. For all these conditions, that's just the one rating you get. So that's why understanding that bundling is key. But this is where people get confused because they think DoD bundling and VA bundling is the same. It's not. VA bundling is done because they're trying to avoid pyramiding. And I won't go too far into pyramiding. Suffice to say, pyramiding is simply they are not allowed to pay you twice for the same condition or the same symptoms. They're affecting the same body system so that essentially, let's say for like the back condition, you can't bend. Well, if you have multiple reasons why your lumbar spine can't bend, they can't keep paying you for all these different diagnosed conditions when in actuality, your diminution of earning potential is simply because of the bending. So that's pyramiding. Of course, oversimplified. But that bundling, very different. And Springs doesn't say that's wrong. They have no opinion on it. That wasn't even an issue in the case. So what's wrong, or I should say what the Springs case is trying to alleviate, is the wrongful DoD bundling, not the VA bundling. So if you have, let's say, a hip condition, and you have multiple issues with your hip, and the VA bundled these 3, 4, 5 conditions together and said 10%, the DoD can't remedy that. They have no power to remedy that. They never had power to remedy that. Because remember, in the IDES, the DoD does not rate you. And people say, what about LDES? That's not IDES. What about TDRL? TDRL is after you've already been temporarily retired and you come back for a re-examination, and it's not the initial stages of the IDES. In the IDES, the DoD does not rate you. The VA rates you, and the DoD cut and pastes that rating. So some will disagree with me and say, oh, that's the DoD rating you. If you want to call it that, you can call it that. I don't, because it confuses everything. The DoD cuts and pastes when it comes to the IDES and the initial stages of the IDES. That's how they do it. So if you think that's rating, then I guess you could say I run marathons because I watch marathons. I don't. And most people would say that's not running a marathon. Well, just like this, I don't consider that the DoD rating anyone because they're cutting and pasting. They're not doing the ratings. So that being said, if the VA bundled everything, then, and the DoD just cuts and pastes, they don't have any power to rip apart that bundling by the VA and then add it all up. That's not within their power under Springs. So when you get this notice, you're going to get a matrix. It can be confusing. And I'll tell you what the columns are. It'll have multiple colors. It's just an Excel spreadsheet. and it's the condition starting at the left, what the condition you were found what potentially unfit for. Then you'll have the category. I mean, 1, 2, 3, or 4. Remember, not talking about 3 or 4. Doesn't really apply here. So it'll say the DoD category. Then it'll have whether it was found unfit or fit. Then you'll have the VA rating under which it was rated. And then you'll have the original DoD disability percentage. Then it'll say Springs disability percentage. And lastly, it'll have the bilateral factor, whether or not that's applied. Sounds complicated, and it kind of is, but it's really this simple. If you look at your VA decision letter originally, and let's say you're found unfit for a hip, and it has five different conditions all bundled together and it says 10%, then that's what it's going to stay as. But let's say you're found unfit for your back, like in Sissel, and you have bilateral radiculopathy, and there's, let's say, 2 more percentages. Let's just say 10 across the board. So 10 for the back, 10 for the right leg, 10 for the left leg. Well, then that's where you'll see in the Springs case and under this matrix, you'll see back, category 1, unfit, and then 10, 10, no bilateral. And of course, the back VA code can be multiple of them, but many different ones. So I won't assume. But then you'll see the bilateral radiculopathy, the left lower extremity, the right lower extremity, and you might see, let's say, it'll say category 2, unfit, and maybe it'll be like 85-20 because it's a nerve code. And then it might say original DoD disability percentage, 0, and then Springs, 10. And then, of course, bilateral factor would be applied because if it's bilateral radiculopathy. And then at the bottom, it'll say what your new DoD percentage is. And in this case, it should be 30. And then you'd be going from separated if the person was just given 10 to 30 retired. That's a very basic, simple example of what that matrix would produce. But you can see this isn't very easy. It's actually easier to understand what bundling is, meaning VA bundling and DoD bundling. And if you really understand that, everything else logically follows. But if you're having trouble grasping this, you're definitely not alone. Most attorneys take a while to understand this and to really grasp the idea of pyramiding and bundling, DoD bundling, VA bundling. If you're a service member and you have a question about this, if you're thinking, you may have an issue with this and you want to appeal to BCNR, Board of Corrections for Naval Records, because that's how you would do this, please go to my website, joelpettitlaw.com, give me a call, shoot me an email. I'd love to speak to you about your potential case. If this video has helped, please click here to watch more. Otherwise, thanks for watching, everybody, and have a great day.